Welcome to today's video. I'm Richard Chapo. I'm an attorney in San Diego, California. I've been advising online businesses for about the last 20 years. It's a Saturday morning. I almost said 40. And today we're doing an introduction to the California Consumer Privacy Act. So this is a new privacy law in California that went into, didn't go into effect. It was signed into law in the summer of 2018. Now, don't panic. It doesn't actually go into effect until January 2020. And even that date's a little fuzzy at the moment because the California Attorney General is supposed to issue regulations under the law and has indicated it may not get to, the office may not get to that task until the summer of 2020. So, however, there are look-back provisions in this law. They require you to be tracking things as of 2019. So it's important to get your act together now. The California Consumer Privacy Act is often referred to as GDPR-lite. The GDPR is the General Data Protection Regulation, state privacy regulation that went into effect in Europe, in May 2018. This is a pretty lazy interpretation. There are a couple of similarities between the two pieces of legislation, but the California Consumer Privacy Act is not nearly as overbroad and brutal as the GDPR. So, for example, the GDPR requires you to have legal basis to collect personal information from individuals, and it takes the position that there are maybe 7 ways to do that, of which the most common is consent. So you would have to get consent from people before you collect their information. This is why you see all the cookie pop-ups on sites. The California Consumer Privacy Act does not require that. So it's a major difference. But there are some general similarities. So let's just dig into this. Expanded definition of personal information. So historically with privacy laws, we looked at personal information and defined it as the things that maybe you would have thought of, through time. The name of a person, their street address, their phone number, their email address, maybe their social security number. Now, realistically, that information doesn't really work anymore. It's not really accurate when we consider the way the digital world works. I mean, just think about when you're online, you do a search on Google or wherever for some subject, and then for the next week, you see ads related on that subject. That's because, in the netherworld of the internet, a profile has been built for you, and it's being updated constantly, and you're being shown ads that reflect that profile. And that profile usually doesn't include your name, your street address, your phone number, or your email address. They're just independent identifiers. And so the definition of personal information under this act, as well as almost all new privacy laws, is expanded to try to address that. So, for instance, under the Act, I'll just read it to you. Personal information is broadly defined to mean, quote, information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. Now, does that seem a bit broad? And the answer is yes. And again, because they're just trying to cover all the different types of technology that can be out there now or could reasonably be created here in the very near future. And, so basically your default view at this point may well have to be that pretty much any information that can be used to identify a person directly or indirectly, or their household, is now considered personal information under the Act. And that's a bit scary. If you think it through, it really is. But that's where we're headed with privacy law. So, second thing, new privacy rights. Now, this is an area where we are looking at something that's a bit similar to the GDPR. And this is the idea that we're going to give consumers the right to know what people are, or know what companies are collecting about on them, what it actually says, how they're using that, are they selling it, and in some cases give people rights to get rid of their information. And you can see those rights listed here. So right to know, this is the ability of the person to ask a company, what are you collecting on me? And there's a look back period for this of 12 months. So I could contact Facebook and say, hey, I have a Facebook account. I want to know all the personal information you've collected on me. What are you doing with it for the last 12 months? And if I did it today, it's January 11th as I record this, January 11th, 2019. And if the law was in place right now, which it's not, but if it was enacted, Facebook would have to look back to January 11th, 2018 and tell me what data they've collected from me since then and what they've done with it. And so will you. Now, keep in mind, California Consumer Privacy Act has thresholds. If you go to our homepage and look at the playlist for California Consumer Privacy Act, you'll see different definitions or different videos. One is for thresholds. I suggest you watch that because you want to make sure that you don't comply with the act if you don't need to. Right to access. So, as this suggests, a consumer will have the right to see what you actually have on them. So, you would have to either give them access to the data or perhaps send them an email listing all the data and what have you, so they can then react to that. See, right to deletion. In certain situations, a consumer can ask that their information be deleted. So if they're on your opt-in email list, they can ask for it to be deleted. If you're holding it for some other reason, they can ask for it to be deleted. However, this area is ripe for loopholes because California is not going to be able to require you to delete information that is otherwise required by other laws to be maintained. So if you have situations such as legal dispute arises and somebody serves a subpoena, well, the consumer can't contact you and say, hey, delete my information instead of providing it for that subpoena. D, your right to opt out. So if you're selling the information of the person, they can tell you to stop. Don't sell my information anymore. And that will probably be followed up by a request that you delete it. So the idea here again is we're trying to give some control to consumers. E, the right to equal service. And so this refers simply to the fact that if a person exercises any of the other rights under the Act, that you cannot treat them differently, i.e. you cannot discriminate against them. And that kind of makes sense. It's not too much controversy about that, I wouldn't think. So does the Act carry any bite? And so we're talking about potential damages for violations. And the answer is yes. The California Attorney General is responsible for enforcing the Act on behalf of the California government and citizens of California. If you are a person who is a natural resident, lives in California, congratulations. And no, you're not getting any money. The AG can bring actions for damage claims of up to $7,500 if it feels or wants to assert that the violation was intentional or willful on your part as a company. If it's just a situation involving negligence, that drops to $2,500. Whatever the AG recovers, 20% of that goes to a fund that is used to further actions, to fund further actions. And so this is a self-funding act, if you will, and that's usually not a great idea. Because then the AG suddenly has an exterior motivation to pursue more and more actions so that it can develop a larger and larger budget. So we could see some pretty aggressive prosecutions under this act. This isn't a situation with other laws where maybe prosecutions aren't all that prevalent or all that frequent. Something like the Children's Online Privacy Protection Act, where the FTC gets off their butt maybe once or twice a year to bring an action. I think California is going to be pretty aggressive with this. There's also a private right of action. So what does that mean? It means a consumer can sue you privately in court and claim damages up to $750 per violation of the Consumer Privacy Act. Now, that may not sound like a lot, but there is an allowance for class action lawsuits, and that means that consumers can group together in one lawsuit. And so if you have a website or an app and you've violated the California Consumer Privacy Act one time with one person, you've probably done it multiple times. And so if you have, let's say, 10,000 people that you've collected personal information from who are California residents, that class action could involve 10,000 people with a damage claim of $750 per person. And you can see that number starts getting large and scary. And the attorneys will also try to recover their attorney's fees as well. So we're talking about some significant bite there. Now, the privacy right of action currently only really applies to data breach situations. So data breaches that involve some aspect that have violated the California Consumer Privacy Act does not apply to other areas at this time. However, this law is ripe to be amended in the run-up to January 2020, so that may change. So you're going to want to keep an eye out for that. So that's it for this kind of introduction and overview of the California Consumer Privacy Act. Again, this is not comprehensive in any way, shape, or form. There are other rights and obligations and acts under, and requirements under the Act. For instance, there are requirements for collecting data from minors who are 13 or older, but under 16. And things of that sort that we'll dig into. We'll be creating a playlist. You can go to our homepage on YouTube and look into the playlist for the California Consumer Privacy Act that will contain videos on all these different subjects. That's all in process right now. But you want to make sure that you at least have an understanding kind of overall what's happening with the act. And basically what the overall impression is we're expanding personal information, the definition of personal information, to be very broad. And then we're giving consumers rights to essentially know what information is being collected by them, how it's being used, who it's being sold to, and certain rights to perhaps stop or change how that is occurring. And if companies don't comply with this, the important thing to keep in mind is the act has some bite, and the Attorney General for California is expected to be pretty aggressive in enforcing it. So that's it for today. Thank you for watching, and have yourself a good one.